symposium reflects a year's worth of hard work by the symposium editor, who many of you have been working with, the wonderful Kelsey Moore. And she has been advised by our longtime advisor to the Law Review, Jonathan Enton. And for those of you who were here, you remember that last summer we had a special session, a ceremony in honor of Jonathan Enton's second retirement from the Law Review. He's now been taken over by our newest professor, Betsy Rosenblatt. And at that ceremony, we raised enough money to have an endowment for a prize and to help support this endowment for this symposium. So this symposium is in honor of Jonathan Enton. And then none of these programs that we run, and we run about 35 major conferences and events a year, are possible without our wonderful event staff. And that's Eric Seiler there, and then wandering around is Alim, who is our assistant from Russia that helps us with these events as well. So this one is going to be particularly sad for me because I like to do these welcomes at the Law Review symposiums, and this will be my last symposium that I can do a welcome for the Law Review as the co-dean, because we announced this week that Jessica and I, at the end of June, will be stepping down after 10 years as the co-deans. That doesn't mean we're leaving the law school. And in fact, with all the stuff going on in the world, I am eager to return in my former position as Associate Dean for Global Legal Studies and get my hands back in the world of international affairs. And maybe along with our students, we can help make a difference. Well, talking about places that need help, that's our judiciary. And it used to be that the judiciary was the least dangerous branch of the government. In fact, in opinion polls, the judiciary always outpaced the Congress and the president. That's not the case anymore. Things have gone off the rails, and we're going to hear about that today, and we're going to learn about what can be done about righting that. This is a really great time for this symposium, and this law school is very proud to be hosting it. Now, our co-sponsor is the Federal Bar Association, and Jonathan Enton is going to say some remarks on their behalf. Thank you all for being here.
Thank you, Michael. I'm actually inclined to ask for, or to use this time as an opportunity for rebuttal to some of the things that Michael had to say about me, but I won't. I do want to correct the record, though. Michael and Jessica have been in the dean's office actually for 11 years, 10 as co-deans and one as interim co-deans, and we will miss them enormously. Now, this program would certainly not be possible without the great work that Kelsey Moore has done to put it together, and other folks she's been working with. But this program also would not have been possible without the help of two sources of outside funding, and I just want to take a couple of minutes to acknowledge those sources. One is the Attorney Admissions Fund of the U.S. District Court for the Northern District of Ohio. We have had the Law Review has had a very productive relationship with the Northern District over a long period of time. The court has been generous in supporting not only this symposium, but a number of our previous Law Review symposia. And so I want to take this opportunity to thank them for their support once again. The other source of outside support for this program is the federal litigation section of the Federal Bar Association, which has also generously supported this program. And I want to take a minute for those of you who are not members of the Federal Bar Association to encourage you to think about joining. If you are a law student, student membership in the FBA is free while you're in school. And the Northern District of Ohio chapter, on whose board I served for nearly 15 years, is an especially active chapter. So There are lots of things you can do, and we have a really good student chapter. I encourage you to think about that. The federal litigation section has people from all over the country, terrific litigators. Again, folks who know federal courts very well from the inside. And so there are good reasons for you to think about joining. But aside from that pitch, I want to wrap up simply by saying that we are really grateful to the Fed Lit section for their support. Again, without them and the Northern District of Ohio District Court, this program would not be possible, at least in the form that it will take place today. So big thanks to both of them.
Good morning, everyone. Thank you for being here on a Friday morning in the fall. My name is Kelsey Moore. I am the Executive Symposium Editor for Volume 74 of the Case Western Reserve Law Review. And putting this event together was a monumental effort, and I certainly did not do it alone. I had a lot of amazing help, both from faculty, friends, and people within the legal community here in Cleveland. So I want to start by thanking some of those people, in particular, Eric Seiler, who has been a dream to work with and help with the logistics, travel, planning our nice dinner that we had last night, assisting with tech needs, all of that. So thank you so much, Eric. This really would not be possible without you. I also want to take a moment to thank Meg Heller, who works here at the law school. She was very helpful in getting a web page posted, in helping us promote the event. And I want to thank Dean Scharf as well for opening, and as well as helping us connect with the publicity marketing department at the university at large. I had amazing help from both of my law review advisors in the time that I was working on this project, Professor Jonathan Enton and Professor Betsy Rosenblatt. It's been a joy to work with both of you, and thank you for all of your help and guidance. My inspiration for this topic came about a year ago when I was sitting in last year's symposium, and I saw what the outgoing symposium editor had put together, and I was just really inspired. I thought it was a cool opportunity to bring together people to share thoughts and promote discussion around topics that are timely and relevant and interesting, and maybe that we don't necessarily talk much about in the classroom. I was also taking professional responsibility at the time, which for anyone that's taking right now, actually some of our colleagues are taking the MPRE as we speak, so my thoughts and prayers are with them. But that was really kind of my first exposure to this idea of ethics in the legal profession, and I was stunned when I learned that there's no binding code of ethics for the Supreme Court. That just did not really make sense to me, and the more I dug into that, the more I discovered this whole world of judicial ethics, both on the federal and the state level. So I'm excited today that we have speakers that are going to be discussing ethics and reform in both of those arenas. I want to thank all of our presenters that made time and put in the effort to either be here in person or to appear on Zoom. I'm really thrilled with the lineup that we have today. I think it's going to be very worthwhile, and thank you all again for being here. Before we get started, for the people on Zoom, I just wanted to let you know that the CLE information will be provided at the end of the program. There will be a lunch break at or about noon, and we will resume the program at 1 p.m. Eastern time. And I think that's all for me. I'm sure you're anxious to hear from these brilliant people seated behind me. To moderate this first panel this morning, we have our very own Professor Hardaway, and she's going to kick us off with some introductions, and then we will roll into the panel. Thank you.
Professor, is it Shen? Okay, I want to make sure I said it right. Good morning, everybody. I'm delighted to be the moderator for today's panel. Oh, good. Okay. Judge Dillard is on Zoom.
Yes.
Thank you. Delighted to be the moderator for today's panel, and I'd just like to give some brief introductions of the panelists. First, we have Judge Stephen Dillard. Presiding Judge Stephen Lewis A. Dillard was appointed as the 73rd judge of the Court of Appeals of the state of Georgia on November 1st, 2010 by Governor Sonny Perdue. Judge Dillard was then elected and re-elected by Georgians in 2012 and 2018. He currently serves as the presiding judge of the court's 4th division. We also have with us Douglas Keith. Douglas Keith is senior counsel in the Brennan Center's Judiciary program, where he works primarily to promote fair, diverse, and impartial courts. Keith is also a founding editor of State Court Report, a Brennan Center publication focused on state courts and state constitutional law. Previously, he was the George A. Katz Fellow at the Brennan Center, working on matters related to money and politics, voting rights, and redistricting. His work has been featured in the New York Times, the Washington Post, NPR, Atlantic, Guardian, New York Daily News, and the Huffington Post. I should also say that he previously worked as the Ford Foundation Public Interest Law Fellow at the Advancement Project, organizing voting rights advocates in New York. He served as an international election observer for the National Democratic Institute and the OSCE Office for Democratic Institutions and Human Rights, and he trained poll workers for the New York City Board of Elections. He's a graduate of the New York School of Law, NYU School of Law. My apologies, Keith. And Duke University. We also have Sarah Cravens. I think I went out of order a little bit. Please forgive me. Let me go back to Professor Shen. Professor Shen's scholarship and teaching addresses various legal subjects through doctrinal, comparative, and empirical perspectives. His research has focused on multiple aspects of the legal profession, including the exercise and control of prosecutorial and police discretion, police interrogation, Miranda warnings, prosecutors' socialization experience, institutional reforms in prosecutors' offices and police agencies, and formation and production of elite cultures in professional legal settings. He has published in both English and Mandarin multiple journal articles and book chapters concerning legal profession and criminal justice with sociological, comparative, historical, and empirical perspectives. He helped design a series of courses on the American criminal justice system for Taiwanese lawyers and judicial apprentices in the Academy for the Judiciary in Taiwan. While working as a fellow for the nonprofit organization Fair and Just Prosecution, he conducted several policy reform projects that focused on wrongful convictions, the use and misuse of criminal justice data by prosecutors, and the best practices for designing and incorporating conviction integrity unions into modern prosecutors' offices. And I'm all over the place because I thought I was going through alphabetical order, but then I realized I was going through the order on the program that you sent me.
You're great.
I'm not. Professor Cravens. Sarah Cravens joined Washington and Lee Law in 2023 on a 2-year visiting appointment, teaching conflict of laws and professional responsibility, among other courses. Professor Cravens has both taught she has both teaching law school administrative experience, including most recently at the University of Tulsa College of Law, where she was a visiting associate professor since 2021. Professor Cravens previously taught at the University of Akron School of Law from 2005 to 2019, serving as the C. Blake McDowell Jr. Professor of Law and filling a number of administrative roles. In addition to her work as a faculty member, she was a law clerk on the United States Court of Appeals for the 10th Circuit and an associate at Arnold and Porter LLP in Washington, D.C. And then we have Adam Sopko. Adam Sopko is a staff attorney with the State Democracy Research Initiative at the University of Wisconsin Law School. Adam joined the initiative following a clerkship with Chief Justice Stuart J. Rabner of the Supreme Court of New Jersey. He graduated from Northwestern Pritzker School of Law, where he served as the editor-in-chief of the Northwestern University Law Review. As a law student, Adam served as a student attorney in the MacArthur Justice Center's Supreme Court and Appellate Program, where he contributed to numerous briefs filed in state and federal appellate courts. He spent his law school summers at the Brennan Center for Justice and the ACLU's program on freedom of religion and belief. His research has appeared or is forthcoming in the North Carolina Law Review, University of Illinois Law Review, the Virginia Law Review Online, and among other journals. Thank you. Would you please join me in welcoming our panelists? I don't know, yeah, the order, you have it? Okay.
Thank you, Professor Hardaway. So we are going to have Judge Dillard kick us off this morning. I also realized I failed to explain the panel setup. So each presenter will speak for about 12 minutes, and then we will open it up for a brief Q&A where you can ask questions directly to each panelist. And then after the fifth panelist presents, we will open it up for a moderated, facilitated discussion and Q&A. So without further ado, take it away, Judge Dillard.
All right, well, good morning. I wish I could be there with y'all today, but it's an honor to speak with these distinguished co-panelists. I do want to say at the outset that your school produced one of my heroes and mentors, Judge Herbert Phipps. He's previously served as a chief judge on the Court of Appeals of Georgia. He was an amazing and renowned civil rights litigator before he came to our court. And your school is represented well here in Georgia, thanks to Herbert Phipps. He really is an amazing man, an incredible jurist, and he's just meant the world to me. So I thank you for producing such an exemplary person and jurist for the state of Georgia. So I think what I want to talk about is a little bit about judges using social media. It's not something that has always been embraced by the legal profession or the judiciary, but it's something that I chose to become engaged in early on in my career. Shortly after I was appointed, I signed up for Twitter, which is now, I guess, referred to as X. And, I initially just kind of dipped my toe in the water by mentioning things like where I was giving speeches, things along those lines. But I quickly gained a decent following. I think mostly people were just curious to see what I would do. Maybe it was, I don't know if they were waiting for, like looking at a car accident, waiting for something bad to happen. But I think, I eventually got a message from one of my law student followers who said something along the lines, look, I think it's great that you're out here, but if you're really going to make the most of this platform, why don't you talk a little bit about what it's like to be a judge? Why don't you share those insights with the rest of us and use this platform, in a different way, in a kind of more engaging way? And I really took that to heart. One of the things I like to say is that judges are different, but they're not special. And what I mean by that is that judges should be different in the sense that we should never be, whether we're elected or appointed, we should never be partisan actors. We should never engage in any conduct that would cause someone to question whether or not they're going to get a fair shake before our courts. That said, we aren't different in the sense from any other public official. We're public servants. We serve the people. And I think for the longest time, judges have acted differently. We've been more disengaged from the public, and that's not a good thing. I think you see that probably, mostly at the federal level. A lot of our federal judges aren't as engaged. They have life tenure. They're further removed. But you've also seen that over the years with state judges, and I think that's changing, and I think that's a good thing. I think one of the things that being on a social media platform can do is it can provide accessibility to the judiciary in a different way than we've seen in the past. Not, like I said, I think that's a healthy thing for our democracy. I think it's important. And that's just how I've chose to proceed. I wanted to use social media to make myself and my court more accessible, more transparent, and also to humanize the judiciary. I think that's important as well. I think it's crucial for the judiciary. Someone mentioned in the opening remarks about the fact that the judiciary has historically at least had higher approval ratings, but that's starting to change. And in a way, by many federal judges, understandably, I guess, choosing not to engage in social media. They don't have the incentives that the rest of us do, who have to actually get elected by the people we serve. They don't have the incentives to get out there and to be among the people, not only in person, but online. And so I think the state courts and state judges have a real opportunity to help enhance the reputation of the judiciary by using social media. And I know a lot of you are thinking, well, there's already been many incidents where judges have harmed in some ways the judiciary by their conduct on social media. And I think that's fair. But my point is, whether it's on social media or in person, that can happen. And to me, transparency reveals what it reveals. And I don't think that's necessarily a bad thing. If there are certain judges that are behaving in a way that is damaging to the judiciary, I would rather see that revealed on social media or in person, so that steps can be taken to remove those people, those judges, from office. So once again, transparency reveals what it reveals, but social media can also be a powerful tool. It can be a powerful tool to engage in civics education. It can be a powerful tool in promoting things like live streaming of oral arguments. It's one of the things that I've been a champion of here in Georgia with our court. We started doing that in 2016, educating the public and about what we do on a daily basis. One of the things that you hear typically around election time for those judges who are elected is we don't know anything about these judges. And so on the one hand, people want that information. On the other hand, when judges use the one tool that is fairly accessible and affordable to try to say to the public, hey, this is who I am, this is what I'm about, there's this discomfort in the media and in our profession with judges actually engaging the people we serve. And I just don't, I think all in all, it can be a net good for judges to be available and accessible and transparent, and to use social media for things like educating the public about what we do, mentoring law students. I've held Q&As on Twitter and other social media platforms, giving recommendations in general about oral argument advice, writing tips. I don't think that judges sacrifice the dignity of their office by being accessible to the people we serve. Like I said, I think for many, many years, judges have been viewed as these kind of detached, robed philosophers. And I don't think that's a good thing. I think it's important for judges to remember that we are public servants. We serve the people. And in that way, we aren't any different than any other public officials. What makes us different, as I said, is the fact that we should do everything in our power to make sure that we're not seen as partisan actors. Georgia, thankfully, is a state where we don't run under the banner of a political party. I will just confess that I think that is insane that states require judges to run under the banner of a political party, whether it's Republican or Democrat or any other. So I'm proud. I know we could have a whole symposium about judicial elections and whether those are a good idea. But I think if you're going to have judicial elections, Georgia does it the right way. We're nonpartisan. our appellate judges and justices run every 6 years. We're directly accountable to the people. I think that's the way, if you're going to have judicial elections, that you should do it. They absolutely should be nonpartisan. I like to say, with many states surrounding us that have to run, affiliated with a political party, Georgia is an oasis in a sea of political insanity. You see some of the commercials coming from other states. And so to me, social media, as I said, is a way for me to engage the people I serve, to be transparent, to try to humanize the judiciary. And I think that's a positive thing. And as I said, the federal judges have basically left the field to us. And so we have a real opportunity, I think, when many federal courts, including the Supreme Court of the United States, are viewed as mysterious and not being as transparent as they should be. State courts have an opportunity to educate the public about what the judiciary does on a daily basis, and to hopefully give people greater confidence. And the thing is, a lot of our discussion, both in academia and also in the media, is kind of outsized in relation to the daily importance of what courts do. I mean, the focus is almost always on the Supreme Court of the United States. And one of the professors on the stage can correct me if I'm wrong, but I think in the last year, they've taken 78, 80 cases. They take 78, 80 cases a year. I handle that by myself on the Court of Appeals. I handle that many cases. Granted, they're not perhaps as complex, although some of them are, in about a 6-month period. That's just me. And so state courts do the yeoman's work of the American judiciary. The vast majority of people will never have any interaction with the federal judiciary. And, putting aside even my own court, the state appellate courts, it's really the lower courts where justice is going to happen in most cases, whether it's a municipal court, a probate court. So those positions are crucial. And so once again, I think having judges who are out there, who are explaining what their courts do on a daily basis, and who are humanizing the judiciary through social media, I think that's a positive thing. I've been talking about this now for several years. This started with an article in Judicial with Duke University Law School, and then I wrote another article with my good friend, former Chief Justice Bridget McCormick, from the Supreme Court of Michigan, in an appellate practice and procedure journal. And it's something I care about, because I think it really is important for judges to remember that we serve the public. And so I don't think it is, I don't think it hurts the dignity of my office to be transparent and to be accessible to the people I serve. And so I know not all of my colleagues agree with me on that, but I've tried to use social media platforms as a way to educate, to inform, to create greater transparency. And I don't just use my own platforms. I try to do a lot of podcasts also to get the word out about the importance of judges actually being human and being, once again, being accessible to the people they serve. There's a lot more I can say, and I know I'm leaving a lot out, but I may be running up against the 12-minute mark. And unless there are any objections, I'd love to take any questions that anyone might have. Any questions? I may not be hearing the audio.
Okay. No. I'm coming. Also, if anyone has questions on Zoom, please feel free to drop them in, and we'll make sure that we get those addressed too.
So a question about dignity. Humanizing judges sounds great, but the way that social media is set up, a lot of the kind of appeal of social media is the give and take of embarrassment. And do you have thoughts on how judges who are engaging in social media can draw the line between humanizing themselves and being the kind of human that we might not respect, not because they're engaged in misconduct, but because they're engaged in things that might seem frivolous or disrespectful to or idiosyncratic in ways that the public might be able to ridicule?
No, I think that's a fair question, and I think I think it's all, I guess, a matter of how you view the role of a judge. And once again, at least from my side, if I'll just think of some examples. Bill Clinton went on Arsenio Hall and played the saxophone. I mean, did that harm the dignity of his campaign or him being president? I can think of numerous other examples. So the question is, does my posting about the kind of music I'm playing in chambers, does the fact that I post photos from my alma mater when I go to college football games, does that harm the dignity of my office? I don't think it does. Some people may disagree with that. Some people may think that judges are better, rather than being seen or heard, they just need to stay behind the scenes and kind of sit in their ivory towers. I posted today about the fact that this is our distress day for our court. We have 3 constitutional deadlines a year. I wrote a law review article for Mercer Law Review a few years ago, and that explains kind of this these unique deadlines that are particular to Georgia. So I use that as an opportunity to link and highlight that article to educate the public about what we do. But not everything is like that. And like I said, sometimes I'm writing about oral argument tips or writing tips, but sometimes I'm talking about college football or music. I think it's okay for judges to have a life outside of the courtroom. And for those of us who have to get elected, the reality is not being out there and not being accessible is political malpractice. I mean, federal judges have the luxury of being disengaged from the public, although I don't think that's a good thing. To me, the question is, to me, allowing the public to get a better insight into who I am as a person is not just good for me politically. Once again, I think it humanizes the judiciary and lets people know that we have lives outside of the courtroom. But look, just like in person, you can engage in behavior that is demeaning to the judiciary online or in person. The difference, of course, and this is an understandable objection, is that if you do something that is demeaning to the judiciary in person, the argument, it's less likely to go viral. I'm not sure that's true anymore. I assume anytime I go out in public that there are people videoing everything I say. They're taking videos or recording everything I say. I think you have to make that assumption as a public official. Maybe they are, maybe they aren't. But the idea that you can not be involved in social media and not engage your constituents, that somehow that's going to protect you from a viral moment, I'm not sure that's true anymore. So, I think I try not to do anything remotely partisan. My goal is for every Georgian, no matter their background, to have confidence that I serve them, no matter what their background is. And so I try to have a feed that is free of toxicity, that is, that is encouraging. I try to post things that are positive. But once again, I try to stay completely away from any partisan or political issues. And there are some days where I call those days where things are running a little hot on social media, that I'll just take a break because the temperatures are running pretty high, and so even the most benign posts may be taken the wrong way. And those are just things that come with experience from being on social media. But I think for elected judges, the idea of not being engaged on social media platforms, I think those days are coming to an end, whether it's Twitter, Facebook, TikTok, Blue Sky. The names may change, but the way we communicate is constantly evolving. And I just think the days where judges, especially those elected judges, can just choose not to engage with the people they serve, I think those days are over. But look, your point's a fair one. I'm sure there are people that still think it's strange, although there are many judges now that are on social media. I'm sure there are still people that think that that's a little out of the box, a little unusual. But I also have been heartened to have a lot of people come up to me and send me messages that thank me for attempting to humanize the judiciary and not just and making in many ways the judiciary more approachable and more transparent. I hope that's my goal. I hope I'm successful at it.
Hi, Judge Joe. Thank you so much for presenting today at our symposium. I have a question that I think maybe some other people in the room might be wondering. The internet is a colorful place, and I'm curious how you deal with, for lack of a better word, internet trolls, and in particular, how you feel about the block option.
Yeah, no, that's a very timely question with everything that's going on. I don't block anyone. I have in the past only what I call the bots, but even those now, I don't see the value in blocking when you can mute, and I certainly don't think it is appropriate ever for a public official to block someone that they serve. I just think that is I have 11.5 million, almost 12 million bosses that I serve. And the idea of blocking someone, look, I can mute them. I don't think that I'm required to sit there, and I don't think I'm required to engage someone who's verbally abusing me or abusing me in writing. I don't think I'm required to see or even read those comments. I can mute those and not see them if somebody is not engaging in good faith. But there might be some constructive criticism that is helpful to me that I learned from. I've had some constructive criticism about my court, where people said, I've used your website, it's hard to navigate, or this part, and I've been able to take that constructive criticism back to my folks at the court, and we've changed things based on that sort of feedback. So I think you can usually tell within one response. Sometimes you can tell right away if someone's acting in bad faith and you don't need to engage them. In other cases, it's not as easy to tell. And usually after one reply, I can tell whether someone's engaging in good faith. I don't think judges should feel like we're beneath answering questions that people in the public might have, whether they're from Georgia or not, because, I feel like I represent the entire, not me by myself, but I think any judge represents the judiciary at any level. And it's important for us to care about how judges in the judiciary are perceived, not just for me in Georgia, but nationwide, for all the reasons that were pointed out earlier. I think, these are challenging times for the judiciary in terms of the perception, and we need to redouble our efforts for the public to have confidence in what we do. So, but to answer your question, I think engaging in someone who's clearly a troll or acting in bad faith is a bad idea, but I also think blocking them is a bad idea. You mute them and you move on. But look, you've got to have thick skin to be a public official. That's just what it is. There's going to be people that are just not going to like you for whatever reason, and you just have to get over that. You can't take it personally, because people will take screenshots of you blocking them and they'll post it and be like, oh, look, they can't take criticism, or they think they're better than us, or they think they're beneath engaging with, and that harms, I think, the judiciary. When people you serve, you block them and say, I don't want to communicate with you. I don't think we have that right to say we're going to cut off access to people that we serve. I just think I think putting the legalities of it aside, I think it's not the right thing to do.
Thank you very much, Judge Dillard. We are going to move on to our next speaker, Professor Sarah Cravens.
It is so nice to be back in Northeast Ohio. Can you not hear me? Is my mic not on?
Hello.
It is.
There we go.
Okay, I'll get closer to it. Is that better? All right. So it's very nice to be back in Northeast Ohio again. I am very grateful to Kelsey and to Professors Enton and Rosenblatt for the invitation to be here. The paper that I am talking about today gets at a cluster of issues that, by their nature, can go under the radar for a number of reasons. But the reality is that they are very real issues, both in the day-to-day practice and in the bigger picture of state court judicial systems. And you'll hear some sort of common themes with several of the things that Judge Zillard was talking about. The paper highlights some of the ways in which matters conducted off the record lead to an array of challenges, first with respect to the effective imposition of judicial discipline. And so there we take a quick look at misconduct that occurs off the record, challenges associated with bringing forward legitimate complaints when judges have engaged in misconduct that's not captured because no record was made, maybe at all or maybe in part, maybe because of a relocation into chambers, something along those lines. From there, I'm just going to sort of skim quickly over, in the interest of time, the sort of middle stage, which is the challenge of review and decision making, where there wasn't an objective record of alleged misconduct if a complaint was brought forward in these circumstances. And then finally, we'll dive into the relatively small number of published judicial discipline opinions and the comparatively greater number of private discipline opinions, or not opinions, but the greater amount of discipline that happens off the record and the problem that creates, not only for public confidence, but for the development of the law of judicial conduct and related matters. The fact that it's a further practical deterrent, both in meaningful participation of the public in selection and retention of judges, and for, again, that cycle of bringing more complaints in the first place. So I argue ultimately for more transparency in these and other related areas of judicial ethics and process. So with that, we'll talk first about this problem of invisibility of misconduct. I'm focused here purposefully on the professional side of misconduct. So there is plenty of misconduct that happens outside of the professional conduct for judges, because they are judges are held to very high standards. They are subject to regulation, not just on the bench, but off the bench. But I'm focused here on just the misconduct that happens in their very much the core of their professional role. So when they are engaged officially in the business of judging and no record is created, that's the focus. Within that frame, there are, of course, legitimate reasons why they might be off the record. But it doesn't really matter whether they were off the record for legitimate reasons. There can still be misconduct that occurs. And if that misconduct happens and there is no record, that creates a problem for the person who wants to bring the complaint forward. And in fact, the prospect of invisibility can itself influence some aspects of judicial misconduct. There are already numerous deterrents to reporting judicial misconduct, of course. The lack of that record to support the potential just creates an additional and significant obstacle. So there are, again, lots of forces that converge to deter attorneys, parties, others from filing complaints against judges who have engaged in misconduct. Some of those include concerns about risks to the client's case, potential for retaliation by the judge against the lawyer in future cases, risks to the lawyer's reputation with judges in the same court. We could go on and on about that, but those types of concerns all exist regardless of the perceived strength of the potential complaint. It's just going to get heightened when things happen off the record. Filing a complaint against a judge is going to be a risky business no matter what. It is also a very slow-moving business. you would not necessarily expect to have a turnaround on a matter of judicial discipline any sooner necessarily than maybe certainly many months. Oftentimes it's at least a year, maybe more. So attorneys often would choose to either wait until a client's matter has run its substantive course before that judge, or much more commonly, they would simply let the matter drop and not bring a complaint at all. The client might bring the matter forward on their own, but they would be so much less equipped to do so that what you see is when you look at the numbers for judicial discipline complaints, the vast majority of them are dismissed outright because they are not brought forward on a legitimate ground, or they lack jurisdiction, whatever it may be. And that's mostly the ones that are coming from parties, not attorneys. So in that context, where we don't have an objective record to which the complainant can point, it's less likely that a complaint will be brought forward. And there are lots of reasons why there wouldn't be an objective record of a judge's misconduct in that official setting. In the professional context within the courthouse walls, there can be gaps depending on how well the courtrooms are equipped with audio and video recording equipment in the first place. There can be gaps in whether they get turned on for whatever reason. There is a court reporter shortage across the United States, and so you may not have been able to obtain a court reporter. You may have decided to go forward with that one, either for a whole proceeding or for part of a proceeding. There may have been a decision to go off the record for a specific purpose, and so something happened while you were off the record. There may have been a decision to go into chambers for something and not bring a court reporter in. Obviously, there's a time before and after you went on the record when something may have happened. Something may have happened in the hallway on the way to something or other. Something may have happened in a conference. There are all kinds of reasons that you may have been off the record. And again, those reasons may have been legitimate or not. That's not so much the issue as it is that the conduct happened. And it's in those interstices, large or small, where problematic judicial conduct can lie invisible and unreported, because without a record, it's just too difficult to bring that complaint forward. And like the proverbial tree that falls in the forest with no one to hear it, what we might ask here is, when the misconduct happens without a record being created, were any rules actually violated? Is any sanction actually going to occur? So that's on the front end, right? Is the invisible conduct that's not, nothing's happening with it. In the middle, we have the cases where people say, well, I'm bringing it forward anyway. And sometimes they do that simply because it's too big a deal to ignore it, or they might do it because maybe they have a cell phone, they have their own recording of it, and so they have something to go on. Or they have enough witnesses that they're willing to sort of say, I'm going to do it, or I'm just going to do it on my own report. The problem there, just in the interest of time, I'm not going to go into the detail on this, but just say the problem is that when you're relying on witnesses, you end up with a lot of cognitive biases and heuristics that come into dealing with the witness testimony and who your decision makers are. That tend to complicate those opinions. And I'm happy to say more about that if it is of interest. But I want to skip forward to what is, I think, the more problematic piece of this, which is on the other end of things. When we look at the discipline that is happening again across the United States with state court decisions, we have about, depending on how you count them, somewhere around 30,000 state court judges in the U.S. And when you look at any given year, about 100 to 120 public discipline opinions total. Everything else is informal, private discipline, or peer-to-peer, just counseling of judge to judge. Or not happening at all, right? Judges, at least talking to me in private, saying, yeah, nothing's happening about that. This is, that there's a problem there, but nothing's happening. So the fact that is the reality that we mostly as the public don't know about the violations that are occurring, paired up with the fact that in the majority of states, we are asked as the public to elect and retain judges without knowing of the violations is problematic. So if we are intelligent enough to be asked to make the choice or to elect, re-elect, and yet we are not thought to be intelligent enough to discern the difference between these are bad enough instances that they are made public. And the others, and so the language you often see of why some are informal and private is that, oh, this was only one time, or this was minor. It was a violation. They're very candid in the language of saying why we have informality is to say it is because, oh, it was just minor, it was one time. And it's easy to appreciate, the being a judge, I fully get it. It is, you're out there in the public and it is a tough job. I'm happy to concede that. But there's a problem in saying there's a different standard. And there's a problem for that because we need to be able to have public confidence in the judiciary because it's a position of great public trust. To ask that people come before a judge on the bench and that if you are asked to appreciate that person is being held to a different standard where if they violate the rules they are subject to, they get to be told in private, well, it's one time, we'll just give you a warning and it's all right. But when they dispense their judgment, you're held to the strict rules. That doesn't look so good for people who are supposed to put their trust in that institution. So we have an potential accountability deficit there, or an actual accountability deficit there that has, I think, the potential to corrode the broader legal community and lawyers and litigants alike may lose faith in the ability of the judiciary to self-regulate. In terms of concrete steps to prevent that potential corrosion, I would say vigilance on the part of judges about maintaining a record, vigilance on the part of attorneys in terms of objecting when a record is lacking. For potential complainants, finding the courage to take steps contemporaneously to make a record in some effective manner with respect to any alleged misconduct that has occurred. For disciplinary authorities, being aware of the biases and heuristics that play a role when they're reviewing matters that come forward without an objective record. And for high courts and legislators, depending on, it's different in different states as to who controls that transparency about discipline. So for one example would be in New York, where there's they're very active with judicial discipline. The commission that actually does the judicial conduct there actually would prefer not to have private judicial discipline, but the legislature there has said, nope, you have it. These are the rules. And so there I would say, well, there it's the legislature, they should change it. But they have not. So I would say there, make the move, make it more transparent. So I'll stop there.
Thank you, Professor Cravens. We will go ahead and open it up for any questions that came up. Okay.
I want to ask a question if the student has one first. So if the student has one.
Nope, it's all you.
So thank you so much. What a thoughtful piece and packed with so much information. I am really curious to think about the solution side of this. So I live and I work here in Cuyahoga County, and I dare say that it is hypocritical, opaque, right, and unaccountable in terms of our judiciary. There's no transparency in what happens in all of the 34 common pleas courtrooms and however many municipal courtrooms in any meaningful way. And we have here these that have bubbled to the surface here lately, instances of judicial misconduct where people file complaints against individuals, whether discovered through podcasts or news reports and the like, or
I will say Serial did result in judicial discipline.
so on to my next thing, which is what I want to say is
But it did.
well, not only did it take time, but it's at the end of his career. And what we're seeing in many of these instances is when people have the courage that you speak of, it's often when we know the person is going to age out and no longer be on the bench. Most recently, we saw something this week that's very, very similar, an overturned case by Shirley Strickland Saffold on the basis of bias. She's aged out. The lane for her seat is wide open next year, and there's one person who's got, right? And there's the political sort of party play that comes into aspects of who fills these seats and how long people stay in their seats is a real issue and reality here in Cuyahoga County. So with all of that being said, I wonder what solutions might be in place for both the practitioners who go before, right? Because the practitioners are the ones who see this and know it all the time. And for a variety of reasons, some of which you identified, right, don't bother to file the complaints, whether it's courage, self-preservation, or self-interest, right? And so I'm really curious to know if you have solutions, practical solutions that we could put in place for practitioners or for fellow judges on the bench, because I didn't even get to sort of like the way in which the AJPJs in Cuyahoga County and elsewhere, right, don't really serve a function, a control mechanism function in this way. So sorry for the long question.
No, I'm with you. So I have a whole separate paper, which is possibly just pie in the sky, but I put it out there anyway. It should be coming out in February, where one little practical piece of the puzzle, I think, is that if you had, it wouldn't capture everything, but if any time a judge was operating in their official capacity, things were being recorded. If I mean, all my classes are recorded, right? If now some things might need to be sealed, right? But if there were audio and video recording of what is going on in a courtroom and in a judge's conference room, that would capture a whole lot, right? That of what we're talking about here as well. Not everything, but that would give you a baseline of some of the behavior that otherwise lawyers don't feel like they can bring forward because they don't have any evidence of what happened, right? Now, again, there are lots of instances we could think of where, okay, but that's not going to get at this or that. But a lot of the things you're talking about, you're exactly right that one lawyer doesn't feel like their example is going to be enough. But if we couple that with all the other lawyers, then the other answer for me is bar associations need to be, having conversations about this and finding ways to help lawyers by saying, if you have an issue, have something along the lines of an ombudsperson role, so that people know that they can say there's an issue with this judge, below the level of bringing a complaint, so that maybe there's some aggregation there. Because absolutely, what you see is the only time that it comes to that level of that complaint. But often when it comes to the level of public discipline, it's because now there are 15 issues with this judge. And that's why it finally, someone was able to bring it forward. So you get the Curtis collapse in Oklahoma where there were, hundreds of contempt problems, not one. So I think that's just a couple of ideas, but
so I'll ask a question. Maybe it's best suited for the last question, but I'll plant this seed and then I'd love to hear what everybody thinks about it later. What about mandatory reporting of some sort for both practitioners and fellow jurists?
Well, I mean, you already are supposed to. You already are supposed to. It's just that there's judgment in there, and so.
Okay, I would love to talk more about that.
I'm excited to return to this. We'll take one more question.
Professor Cravens, can we talk a little bit about the relationship between judicial discipline, judicial misconduct on the one hand, and something that Judge Dillard referred to in his remarks, which is the general lack of public knowledge about what judges do, and particularly with respect to elected judges. Where do we put, or how do we prioritize when somebody is up for retention or reelection? How much weight should we put on the judge's record in terms of decision-making and the quality of decision-making on the one hand, and the judge's conduct or misconduct on the other? And to what extent might there be concerns that one or the other might get disproportionate weight, whatever that may mean?
It's a fantastic question that I could talk about all day, and I have to respect the fact that my colleagues haven't given their talks yet. So I'll try to discipline myself here. So obviously there's fantastic work by lots of law professors and social scientists on the fact that as a general public, we actually are not good voters when it comes to the judiciary, both because we lose interest and because we don't have information and all that. So part of what I'm getting at is give us more information, right? Don't hold back information, give us more information. And one of those little pieces is if there is bad conduct, we certainly ought to know it, right? And by the same token, I would say if there's good information, we ought to know it. You know, a lot more information about judicial evaluations, more information from bar associations. Don't hold it back, give that to us, right? So that's the one little piece of the puzzle I'm saying here. But I do think there is a danger that if we just get that information, there would be too much weight put on, you know, oh, this judge violated this one rule, and maybe you could argue, well, that's a rinky-dink rule. Like, why should we care too much about that? We really should care how good their jurisprudence is, you know, but will the general public really understand what that means? Well, if they're not going to understand, then let's not elect judges, right? I mean, if you want to know, like, that's what I think, is we shouldn't elect judges. I get that there are also problems with appointment, but where I land is that, but I'm just saying, as long as we're electing them, give us information. That's my very short version.
Thank you for these excellent questions. Thank you, Professor Cravens. We are going to pass it to our next speaker, Professor Chen.
Here, right here. They're going to put it up, and then there's your class.
Okay. All right. Your microphone. Can you all hear me? Okay, good. So I really want to thank the Law Review for the invitation. I'm very delighted to be part of this panel. I got so many thoughts, so we will have a great discussion today. My name is Stephen Chen. I'm an assistant professor at Cleveland State University, just across town. My research focuses on the sociology of the legal profession, with a focus on questions about legal ethics in the areas of criminal law and criminal proceedings. And today I want to talk about some issues I have been working on about data transparency and accountability, and more specifically about this new idea about open court and what I call it the evidence-based criminal justice 2.0. We'll talk about this new concept. So here's an overview of my presentation. In my presentation, I will begin by addressing some pressing issues about the vast discretion within our criminal justice system and the devastating consequences, including unequal justice and diminished public trust. So then I will talk about the current solution that we have. I call this the evidence-based criminal justice 1.0. So I will tell you why, given its well-intentioned to address the problem, might actually make the situation worse. And finally, I will discuss my proposed solution. Not best, I would love to hear your thoughts about how to develop this criminal justice 2.0 and some of its core features. So we live in a data-driven world. Everything we do generates data. And most of the time, these data are used by firms, organizations to predict our behavior, to prevent mistakes, to mitigate risk, and to increase accuracy, transparency, and consistency. But historically, as you all probably know, This isn't the case in our criminal justice system. For a very long time, we lawyers relied on what they called it unstructured judgment, primarily drawing on our experience rather than using a structured database method to guide our decision-making process. So the absence of a reliable information and transparency within the criminal justice system and the concerns about judges, prosecutors might abuse their discretion. Emphasize this. It's not unique to the American system. Many other countries are struggling the same thing. However, for American people, this issue takes on significantly greater urgency. Why? Well, because of the tremendous amount of discretion we entrust to judges, prosecutors, and police. So through the exercise of discretion, prosecutors get to determine the numbers and natures of charges and how many charges and whether to bring charges. And judges, they make decisions regarding pretrial detentions and sentencing. So here in Ohio, we used to have an indeterminate sentencing structure for offense like violent crimes, where judges will pick a minimum term of prison time, and then there will be a ring, and they will go into prison system, and there will be parole board that could decide whether they could be released or not. But we get rid of that in 1996. We went into a determinate sentencing structure. So it was during the time where there's a tough on crime period and there's a truth in sentencing movement. And we basically took a system that there's a shared power between the three governmental branches. And now we put all the power in the judiciary. So there's almost no checks and balance. The old system is not perfect, but you get the design. The design makes sense because of the checks and balances. And now that all sentencing power is in the state of Ohio, is located squarely with the judiciary. And also, Ohio is one of the most hyper-legislative sentencing states in the country. So it becomes so complex that even judges who is delivering the sentencing don't understand a lot what they are telling the defendant at plea hearing. So according to a report published by the National Center of State Courts, they evaluate 23 states that have sentencing commissions, like what we have in Ohio. And this is, the mechanisms supposed to make sure the sentencing laws are being carried out fairly. Ohio ranked the worst. Wisconsin. The judge has so much power. What's the consequences? Well, you'll get cases like this. This happens here in Cuyahoga County. The report actually happens to cover 2 different sentencing hearings in 2 different judges' rooms, and that was 24 hours apart. You notice some similarities here. What's on the left stole $250,000 from Chevron for School System, where she works. And this woman on the right, the African American woman, she stole $42,000 from the school system, where she works. The woman on the left got probation. The African American woman got 18 months in prison. The same prosecutor handles the case. This case went viral. Even the Attorney General posted, we need sentencing database. This guy is convicted of sexually abusing an 11-year-old boy. He received 6-month prison sentence. And then you have this lady. By the way, this case has been going back and forth between the Ohio Supreme Court and the 5th District. So the woman was convicted of stolen property from senior citizens nursing home. And they were like family pictures and stuff like the traditionally the thief just don't want to take. So you probably, there's mental issue with this lady. And then, she got an attorney and then they entered a plea agreement. The state was silent on what they intended to advocate for at the sentencing hearing. So she had no criminal record, by the way. She entered a plea not knowing what she's gonna get. She entered the plea and 30 days later, they walk in, the prosecutor said, we're asking for 42 years in prison. The defense lawyer said, we're asking for probation. What the judge said, you're both wrong, and gave her 65 years in prison. for property theft. You had no eligibility for parole. Perhaps it's not surprised that we know the lifeblood of our criminal justice systems is that the public have trust that it is fair and just. However, according to the Gallup data, trust in the criminal justice system has remained really, really low, especially when you compare with the medical system. In fact, the criminal justice system is among the 4 worst rated institutions here in the United States. Let's go better than the Congress. First situation. Well, we have the solution. Criminal justice, the evidence-based criminal justice 1.0. So over the past 2 decades, a slow but growing movement has promoted internal data collections, including collections by police, prosecutors, and maybe now judges. So those efforts have focusing on documenting, charging, and other decision-making process in the prosecutor's office and in the police department. So we have prosecutors using big data, or they call it intelligence-driven prosecution strategies that include identifying top priorities, focusing on individuals. When I was working in the DA's office in San Francisco, I was actually part of this team. It's in the crime strategies unit. And we play data, and we focus on communities, and we use data to inform the police and to inform the community. Not only that, we have drug courts and many other types of problem-solving courts. They proliferate. And those courts they try to address the issues that they believe that repeated interactions with the systems can be addressed by using better data. So if we do it effectively, then we can use the evidence-driven, data-driven reform in the court. So we have this. How many times? Okay. So judges also learn how to use risk assessment instruments, right? So in Virginia, 1994, it passed a bill, and it sort of gets rid of parole. And at the same time, they introduced this risk assessment tool. I'm happy to tell you more about how this tool functions. But basically, in Virginia, they try to use this tool to establish a plan that they can release non-violent low-level prisoners. So if the offender's score was above the cutoff, the prison term recommended by the state, the discretionary sentencing guidance will remain in effect. On the other hand, if the offense scored lower below the cutoff, the offender will be recommended for an alternative sanction. Now, what's really the problem with 1.0? Let me show you with this computer model that I generate. It's a computer simulation. So let's imagine you have 500 professionals working in the criminal justice system. Who are they? Well, they are legislators, judges, defense attorneys, law enforcement, victims' rights advocates, and innocence advocates. So, together they form the criminal justice professional network. Imagine these network ties represent the flow of information and interactions. Model that I generate. Let's compare the criminal justice model and the medical model. So using the social network analysis, I generated this 2 model. You can see the difference. This example shows you that, well, look at the criminal justice model. The network looks like a spanning tree. It has a lot of reach. And you will notice that actors do not have many interactions, and that there are a lot of bottlenecks and cutoff in the network that could undermine the transfer of resources and information. That's what we have been talking about. That's why transparency is an issue, because we have so many bottlenecks here. And if we took certain players out of the picture, the entire network will fall apart. And in sociology, we said that there's a lot of structural holes here, but you don't see that in the medical model. So why do we keep comparing the medical model with the criminal justice system? Well, you know what? That's how we learn. The entire evidence-based model was first established by researchers in the field of medicine. We borrow it and we use it to reshape the criminal justice system. But because the culture is different, the social structure is so different, it ends up generating a lot of unintended consequences. And And these issues can be about the unverified risk assessment tools, the disjointed or even biased data collection process, the opaque data process that I observed firsthand in the DA's office. And you have absence of accountability. Where are the risk assessment tools came from? Do we know anything about the algorithms? No, there's nothing. Maybe there's some exceptions, like the one in Virginia, but most of the time, we don't know what is being put in this algorithm. And also, I have stories about lawyers, judges demonize data. So judges resist to this transform to the use of the data. So I have to tell you this story. I recently got a copy of an email that went to 400 judges in a file, and they said, let me quote it, data is mathematical, one-dimensional, incapable of reflecting the complete troubled human mosaic that plays in every judicial decision. Your earned reputation over time as a judge, what you reflect about yourself in quiet moment of reflection. And it's the gold standard of measuring fairness. Unquote. 1 minute, but this is fascinating. It's not that we don't have the tool, but there's a demonization of the use of data. And you see this in Ohio. So there's a lot of resistance here in Ohio. The Senate bill in 2022 mandated that the Sentencing Commission create a centralized database to collect sentencing data. Good, right? But mysteriously, they took that out of the bill in the fall of 2022. And I was able to find the recordings. If you're interested in it, I'm going to read you the transcript. This amendment removed this provision in the bill related to the state criminal sentencing commission, a pilot program. The fear that this could create some unintended consequences. So it's not necessary to be put in the bill. The program will continue as it is. Any questions or comments? That's it. That's the full discussion about why they took this data collection metrics out. So finally, what's my solution? There's a lot of issues that I want to talk about, but what is my solution here? We have to think about the criminal justice, data-driven criminal justice system 2.0. We have to talk about holistic solutions. It's not led by single judges. It's not led by a community. The state has to come up with a holistic solution. Remember the social network that I just showed you. Everyone sort of having their own mind about what is good data, what is bad data. If we don't sit together and come with a coherent way, the data will create a lot of biased outcome, transparency, accountability. It has to be talked about in all 4 different processes in the data processing stage, including how do you collect the data? How do you prepare the data? How do you process the data? And finally, how do you deliver and interpret the data? We need ethics, we need transparency, we need accountability, and most of all, we need to reestablish a culture that will stop demonize the use of data. And we have a long way to go. I'll stop here.
Thank you very much. I'm going to open it up to take a couple of questions. If anyone wants to jump in, go back here.
So I went to law school, so I never had to look at another chart. Most of my career has been in the healthcare setting, so I'd really like to know more about the comparisons. I'm not sure I understand. I definitely saw the sort of, fracturedness and non-centric lack of focus in the judicial network. But I'm curious, what were the concentrations, in the healthcare metric that you used?
Yeah, so the model came from a lot of literature review about the key features of the medical field. And I think one key feature is that there's a consistency about what they're talking about, the outcome. What are they trying to measure? There's a consistency of that. And most importantly, the flow of information. You see a lot of information exchange in the medical field That's why these information are being processed. It's almost like a centralized hub to process this information. So we know what other agencies are doing, but you don't see that in the criminal justice system. Police might have a lot of different databases, but prosecutors might have no idea what they are collecting and what they are capable of processing. You don't see that a lot in the medical field. At least in the medical field, different actors, they disagree with a lot of things, but there are certain key aspects that they agree about. But if you go to the criminal justice systems and you ask, what is good data? What's the data that you want to collect? People will tell you very, very different things. Even in the DA's office, they thought they know everything. But the reality is there's a lot of things that they don't know. So for instance, they have no information from the city government. They have no information that come from the police. So they have to beg them to sort of create a centralized data processing center in the DA's office. It is hard. There's a lot of boundaries. And they have different technician people working with them using different softwares, different algorithms. And sometimes there's an opaque process behind that. And in the medical field, we sort of have an idea about what is behind it. At least we can find it, we can sort of validate it. There's a lot of peer review that happens in the medical field. But in the criminal justice systems, you don't see that.
Thank you.
Thank you. Anyone else with a question? I saw Professor Hardaway. All right, see you.
Thank you so much, Professor Shen. As you know, I think we've worked on a panel together before. So I'm really intrigued and have spent the last 3 years of my life working on that pilot program that they just summarily dismissed with one foul swoop. And so I appreciate you bringing that to light. I'm curious if you could maybe give us some more insights into your thoughts on sort of the use of, I think the slide that you showed out of Virginia was to demonstrate the disparity and sort of the bias that can be built into those algorithms, right? Is that right? Okay, great. Thank you. And so thinking about the cases or the examples that you showed, both out of Cuyahoga County and the Ohio Supreme Court around the disparate outcomes, right, in sentencing, I'm wondering if you could just maybe spend a little time explaining how you view the data, the use of data in leveling out the bias that way, if you could just parse that.
Yeah. Thanks for giving me this opportunity. So I think one really key feature of the Virginia model is that it's transparent. So we know the risk assessment instrument, it can be examined by researchers. But most of the time when we have an algorithm, it is actually, there's lack of public process. So we don't know how they select particular risk assessment tool. So I think during that process, one thing is we need to open it up to the public to let the public know how is the process and how do we validate the tool. That's one thing. The public has to have access to these tools. And secondly, I think, so the one that you mentioned is, we call it the proprietary, non-transparent risk assessment algorithms. And it triggers a lot of issues because the data they got are biased. And the data, the populations of the study for the algorithm was actually not the population that can be validated or used in other jurisdictions. So that happens a lot. And I think one key issue that we are facing is that we need to open this process up. Let us know, let the researchers get in and try to be able to criticize or to validate these algorithms. And what's another question that you have about bias?
Yeah, I guess the question that I would ask, do I need it? I guess the question that I would ask really is, well, maybe I would say, on the sentencing collection, right? I think we're at such an infant stage here in Ohio, right? Like just to get the information might give us some insights into the places where bias, right, exists. That's the first stage or step of this. And I'm curious to know sort of how you view what your solution does to address the second stage of it, which is making sure that there's uniformity, consistency, and right. Okay.
I think education is crucial. And when I said education, it's the education for both judges, lawyers, and the general public. So I have seen studies showing that, well, like I think there's one in Virginia. It shows that there's an algorithm, there's a tools that judges can use, but many judges refuse to use that. So I think the next step that we have after we have the data is to educate judges. How can you use these new database to help you make your discretion, to make it more fair and more transparent? And I have seen people say that, well, I'm just going to use my judgment, my experience, because every case is different. That's the culture thing. We have to address that. And the general public has to know that what's the alternative that judges can use. And also, we need to provide community with the resources. So once you create some alternative, community has to follow up, right? So you said, okay, like the one in Virginia, without prison center, what can you do? What's the alternative solutions? It requires different actors in the criminal justice, in the non-criminal justice system to also play the role here. So I think my key goal is to change the network to sort of make it look like a collaborative network structure so that everybody gets to know what each are doing and we can share the information. It's almost like a Dropbox idea. Think about all of the actors in the criminal justice system are using one Dropbox. They can quickly upload the information to that Dropbox, and every actor can access that and sort of understand what other actors are doing, what other stakeholders are doing.
Thank you very much. And now we are going to move along to our next presenter, Adam Sopko.
Thank you so much. I first just want to thank the editors for inviting me and for all the work that you do. I know sometimes balancing journal responsibilities with classes can sometimes feel like keeping two full-time jobs. So thanks for all the enthusiasm and everything that you do. So my talk this morning is titled Invisible Adjudication in State Supreme Courts. It's based on a paper that I have forthcoming later this year with the same title. And big picture, there are two key themes that animate the project that I think resonate with a lot of the great comments we've heard so far this morning. I think comments we'll hear later this afternoon. The first is just that we have very little insight as the public into the business of state Supreme Courts, what it is that they do outside of just the opinion that they issue. And the second is a related concern that we just know so little compared to the United States Supreme Court, in particular in the federal judiciary in general, about the power that state Supreme Courts wield. And so those two themes frame both the general project and then my remarks this morning. And so there are three topics that I want to touch on this morning. The first is, what is invisible adjudication and why are we talking about it? Why should you care about it? The second is, what are its manifestations and instances of the phenomenon? And then hopefully with my time remaining, just talk through maybe some approaches of how we might respond to invisible adjudication. So what is invisible adjudication? So it refers to the numerous orders and decisions that state Supreme Courts issue outside of just the merits opinions that they release each year. And in most instances, these orders and decisions are unwritten or have little or no explanation whatsoever. This definition may sound very familiar to you as a description of the United States Supreme Court's shadow docket, a phrase I think many, if not most people here are familiar with. And it is. But the phenomenon differs meaningfully at the state level. And I go into greater detail in the paper, but in the interest of time, it differs really for two reasons. First, which is that due to the way that state judicial structures are built, as well as state constitutions, certain unwritten norms, state Supreme Courts have access to a much broader universe of discretionary tools that empower them in subtle but significant ways to affect case outcomes. And second is the transparency issue. That is, relative to the United States Supreme Court, we have very little insight into what state Supreme Courts do besides just those merits opinions that they issue. Again, thinking about the SCOTUS shadow docket, part of the reason why that term exists and we kind of know what it is is because everyone here can pull out their phone or open their laptop, log on to the court's docket, and see the inputs and outputs, see who's filing, asking for the court to do something, the arguments that they're making, what the cases are, and then see the court's ultimate decision, granting or denying that relief. That level of transparency, which we could call it very little, is essentially impossible to right now for most state Supreme Courts. And so I refer to that broader, much less transparent formulation of the shadow docket as invisible adjudication. And to be clear, most instances of invisible adjudication are the kind of prosaic, routine instances of judicial management or docket control that we might expect. But like SCOTUS, there are instances where state Supreme Courts are using invisible adjudication, the discretionary rules that give them more play in the joint, so to speak, to affect case outcomes. And in a lot of instances, these are in really high-profile cases. So why should we care about invisible adjudication? So I think just in general, it's important, and I think that I am in agreement here with my co-panelists here, that we should just scrutinize government institutions that have power over us in general. But I think right now it's increasingly important that we focus on how state Supreme Courts do their job, what it is they're doing, and why, how they do it. Because at the moment, the United States Supreme Court is walking away from the protections of many important constitutional rights or eliminating them entirely. And that gap is being filled increasingly by state Supreme Courts relying on their state constitutions. So racial equality to bodily autonomy to democracy and so on and so forth. These huge issues of our society are being answered by state Supreme Courts. And yet we, despite that outside influence and the prominent role that they're playing increasingly in our society, we just know so little about what it is that they do and why they're doing it. So with that goal in mind, the primary objective of this paper was descriptive and to kind of point out the phenomenon and conceptualize it. And so the kind of heart of my project is taking the instances of invisible adjudication and organizing them into 3 categories to kind of offer like a bit of a vocabulary for people to talk about this state Supreme Court behavior. I explored categories in detail. In the interest of time, I'll just touch on them very briefly. Happy to go into greater detail in Q&A or something. But so the first category are merits decisions. And so this looks and feels the most like SCOTUS's shadow docket. So this is instances where Supreme Courts are issuing temporary relief, like a stay of lower court decision or a vacatur. Also summary relief, so summarily reversing or affirming a lower court decision. Then the other 2 categories are where state Supreme Courts really start to distinguish themselves and where the procedural rules that they're using lack meaningful federal analog. So informational decisions, these are things, for example, like opinion publication rules. That is just not something SCOTUS grapples with. They issue a merits decision and then decide, are we going to publish this opinion or not? But that is very commonplace for many state Supreme Courts. You can see how it might implicate the growth of state law. I think something that Professor Cravens touched on tangentially with disciplinary matters. And then administrative decisions. So these are decisions that flow from state Supreme Court's role at the top of the judiciary, overseeing the entire court system. And again, these are things that just don't have a really strong, reliable federal analog, things like transfer decisions. So for in a number of states, appeals from the trial court actually go to the Supreme Court in the first instance. And then the Supreme Court determines whether we're going to retain it or transfer it to the intermediate appellate court to take a first crack at it. And you can imagine, due to things like mandatory retirements or judicial elections, why a court might want to transfer a case or hold on to it, because that might determine who decides the case. That is, what the court looks like when the appeal finally comes to it. And so we might want to know, what informs those determinations. Okay, so just maybe to make this more concrete, just a few examples that, absent the typo, otherwise track those 3 categories. So apologies for that first one. So the first example comes out of Wisconsin and says administrative, but should say merits. Over a course of a few years, in a couple of cases, the Supreme Court there really dramatically changed the standard that governs a stay of a lower court's decision. And what they did generally, it's it's pretty simple, but generally what they did was they shifted the deference that they give to a lower court's factual findings to 0, to de novo standard, and then changed the otherwise pretty granular interest analysis of the parties that are implicated to a vague kind of all things considered balancing test, and then put a thumb on the scale for the legislature. Even when the legislature isn't implicated, they said that the legislature has an interest in the statute or whatever that's being challenged in remaining on the books. And all of these decisions were made in unpublished orders that to read them, you had to know that they existed and then call the clerk's office and ask the clerk to send it to you in 2023. The second example is informational decisions. And so this touches on a procedure called depublication. So what these procedures do is they allow state Supreme Courts to depublish an otherwise precedential opinion from the intermediate appellate court. And in California, the depublication procedure has no public standard. That is, we don't know why, like some cases are depublished versus others. When the state Supreme Court depublishes an opinion, it doesn't issue any kind of order or explanation. It just notes at the end of the year, these are the opinions that we've depublished. And in the 1980s, then Governor Dugmatian had the opportunity to fill 3 vacancies on the court, giving it a majority of Republican-affiliated justices. And through the 80s and 90s, the court relied on depublication to depublish hundreds of Court of Appeals decisions. And based on some empirical work at the time, the only through lines we could see from those decisions is that they were left to the left of center ideologically and jurisprudentially at the direction the Supreme Court was taking California law at that time. Last example is from North Carolina and illustrates in these administrative decisions. So in North Carolina, justices run, much to Judge Dillard's dismay, as in partisan elections. And this time last year, Democrats had a 4-3 majority of that on that court. And last November, the court had granted review over the summer in 2 really important election cases. One was a redistricting case, and the other was a challenge to a voter ID law. Last fall, there was a really consequential election for the Supreme Court. 2 seats were up for grabs. And in September of last year, the Supreme Court, then 4-3 Democrat majority, voted to expedite review of these 2 really high-profile cases. And under the ordinary appellate timeline, it is almost certain that those voting rights cases would have been heard and decided by whatever the composition of the court was following that November election. But voting to fast track these cases enabled the then 4-3 majority to guarantee that they would hear and decide these cases. When they issued the orders, which are fortunately available on Westlaw, announcing that they were going to expedite these cases, it was, I believe, 2.5 sentences, and essentially just said that because these, the standard in North Carolina to expedite is that it must be in the public's interest. And the orders said that expediting these cases is in the public's interest. Here. That was the explanation that we heard from the court. So this just gives you a flavor of kind of how this plays out. You can see instances of how municipal adjudication can really quickly, what might seem like just case management or docket control, can really quickly affect case outcomes in really high-profile cases. Okay, so beyond that broader universe of discretionary tools that empower courts is this question of transparency, which I think is a word that we're hearing a lot about today. And so in state Supreme Courts, the level of access, there are exceptions. There are state Supreme Courts where you can search their docket freely and pull every filing from ordinary motions to cert petitions, court's orders, and so on. But really, the median state Supreme Court, you're limited to the merits decisions that they publish each year. Otherwise, you have to file formal public records requests, which cost money and take time. Or you have to go in person, like in Iowa, to the courthouse and log onto a computer terminal and print it for yourself, and then drive home and read it. And you might think, like, beyond all of this, well, maybe we can't see specific instances of invisible adjudication. But at least, at a maybe more atmospheric level, we can see extraordinary relief. It's the court is issuing more or less of it, or they're receiving, more or fewer writs asking for mandamus or something of that nature, that would be in like year-end reports, statistics, and data dashboards. But even then, that's a real challenge. There are several courts that, Virginia, for example, where the most recent statistics package is from 2019. And so this is just a real issue, kind of seeing what courts are doing, even at that kind of more macro level of activity. And so in that way, state Supreme Courts are substantially less transparent than the United States Supreme Court, and specific to invisible adjudication, just don't allow that level of public engagement that we've seen with the shadow docket to this day. Okay, so if I've convinced you that invisible adjudication is at least something that we should be thinking and talking about, we might wonder how should we respond? What should we do about it? In the paper, I don't spend a whole lot of time on this. The objective of my paper was primarily descriptive, but I offer a few thoughts about how we might think about responding to it. And so the first is to recognize that many of these features that are prominent in invisible adjudication are specific to the fact that these are state, not federal courts. So again, think like transfer decisions. That's really not something that SCOTUS grapples with. And so when thinking about instances of invisible adjudication or the concept in general, SCOTUS might actually not be the best comparator when you're thinking about how we might tailor our response as a policymaker or whatever. Second is that some of these features of state Supreme Courts are the product of local politics, their history, unwritten norms, and traditions that are just unique to that state. And so what might be seen as over the line, abusive, too far in state A might just be part of that state's history and something that has been just how the judiciary conducts itself in state B. And so kind of tempering how we evaluate instances of invisible adjudication to be sensitive to that kind of state-specific tailoring is something we should do. And finally, and perhaps most importantly, I think any efforts to respond to invisible adjudication should begin in transparency. And specifically, that's just improving public access to seeing what the inputs are going into the court, so then we can evaluate the outputs and its work product fairly and get a better sense of the power that these institutions. Thanks so much.
All right, we're gonna get rolling with questions here, starting with Professor Hill.
Hi, thank you. That was extremely interesting to me. So my question is whether the problem and therefore the solution is really about transparency or about just, politically, or partisan even motivated decision making, right? And not just, not one party or the other, both of them do it, right? But so, I wonder if one downside of making these decisions more transparent might be that then litigants know that this is going on, and then they take that into account and they take advantage of this because, I'm not sure that sort of putting this information out there and is going to shame judges into not doing it or into different kinds of conduct, right? If they are behaving out of political motives, and as your examples suggested in many cases, right? And then they get kind of rewarded for that. They're going to continue doing it and might actually increase the amount of this kind of behavior that is troubling anyway.
Thanks. It's a great question. The kind of like counterfactual is always kind of difficult to parse in the abstract, but I think, we do have one data point that, take it for what it's worth, is, just, a year or two ago, I think we saw what might be the kind of high watermark of SCOTUS's use of its own shadow docket. And there have been no public, Congress hasn't done anything to address it, and there have been no public reform, no reforms from the court itself, at least publicly that we know of. Yet everything that we've seen is that the court has really tempered and slowed down its use of the shadow docket. And I think all of that is based on the fact that we, again, can kind of see how it uses it, and there's public engagement by, scholars like Steve Vladeck most prominently, but several others who talk and kind of scrutinize how it uses that power. And so I think, that is one, not imperfect, but one data point nevertheless, that transparency will serve some kind of tempering function for at least.
I wonder if some of the things that you've talked about at the state Supreme Court level might have analogs, not at the US Supreme Court, but maybe in the courts of appeals. For example, to what extent does the issue of anonymous opinions in state Supreme Court compare with the use of per curiam opinions in the courts of appeals, where at least we know who the judges are, but nobody is taking responsibility? And to what extent does, say, the depublication process in California have an analogy in the non-publication policies in the federal courts of appeals, where the majority of federal appellate court decisions are, quote, unpublished, and there's been a long debate about whether and to what extent they may have precedential value and things like that. And one last thing, and this picks up on one of the cases that Professor Chen talked about, the Gwynn case, which the Ohio Supreme Court just recently reconsidered after the composition of the court changed. This is not the first time that has happened, but this is a little bit like the fast tracking the North Carolina case to head off a change in the composition of the court. I guess what I'm trying to get at is, to what extent can we get some insights into some of these phenomena if we look beyond just state Supreme Courts?
Thanks. It's a great question, and it's something maybe I can do a little better job grappling with in the paper. But I think, big picture, I think, are the implications and the stakes. So again, a decision from the Sixth Circuit on a challenge to an abortion statute is not formally final. That's not the end of the road. Whereas from the Ohio Supreme Court, under the state constitution, it is. So I think it's just looking purely at outcome, the stakes are substantially higher. And so in that sense, comparing, what an intermediate appellate court in the federal system is doing to what the highest court in the state system is doing, I think it's kind of hard to compare the two on that sense. But to your specific questions about precedent and publication, I think that the closest analogy really in the federal system would be SCOTUS's Mungsinger orders. But even then, the big difference, and I think this kind of gets at your question, is that depublication is not an adversarial process. It's like purely just judicial maintenance. And so the court is just making essentially an administrative decision that this opinion should not carry precedential weight in the state, versus in the Court of Appeals, that's typically made in the teeth of the case between the parties. And I think that kind of just gives a different feel to what the courts are doing.
Thank you very much for those questions, and we will roll into our last presenter for this panel.
Great. Thank you all for being here. And again, thank you to the organizers of the symposium. Really happy to be a part of this important conversation. My name is Doug Keith. I'm Senior Counsel in the Judiciary Program at the Brennan Center for Justice. The Brennan Center, for those that don't know, is a law and policy institute based at NYU, which seeks to improve our systems of democracy and justice. There have been lots of references to judicial elections today, and I'm happy to be here as one of your resident judicial elections experts. For more than 20 years, the Brennan Center has documented the political pressures facing state judges and advocated for reforms to strengthen courts and enable them to live up to their responsibilities in our democracy. If there are two takeaways I would like you to have from my presentation today, they are these. One, state judges have long faced unique political pressures distinct from those that federal judges face. And two, in this post-Dobbs era, which Adam, I think, laid out really well what has changed in the new spotlight on state high courts in particular. In this post-Dobbs era, we have entered an entirely new era of judicial politics, state judicial politics, that makes everything that happened before this moment feel almost quaint. I'm embarrassed by some of the things I've written 4 years ago about the politicization of state courts, because they are nothing compared to what it is today. And that just makes this conversation we're having here today that much more urgent. Made a mistake. So let's start by talking about where these unique political pressures and ethical challenges come from. What you have before you on the slide is a map of the how our taxonomy of the judicial selection systems in the United States. You could recode these in different ways and have different colors show up, but I just want to give you a sense of the sort of varied landscape. But I really want to focus on judicial elections today, and so I'm even going to reorganize these numbers further to say that in 38 states, state high court judges and justices face some kind of election to either reach the bench in the first place or to stay on the bench. In 16 states, those are retention elections, which have been mentioned today. Retention elections are races in which judges or justices run with just their name on the ballot, and voters vote yes or no as to whether to give them another term, but they don't have opponents on the ballot. In 14 states, justices run in competitive elections that are nonpartisan, so they might have an opponent, but party labels will not show up on the ballot. And in 8 states, they run in partisan elections. You'll see on the slide behind me, it says 7, and you'll say you're wrong. But as it turns out, one of the states that we list as a hybrid system is New Mexico, in which justices, as part of that hybrid system, also run in partisan races. This landscape is pretty stable, although there are a couple exceptions I'd like to highlight since we are in Ohio. Ohio used to have a fairly unique system in which justices ran in party primaries, got a party endorsement, but then when it came time for the general election, they appeared without a party label next to their name on the ballot. So they were effectively nonpartisan general elections. The legislature in Ohio grew frustrated that their preferred candidates were losing races in the last few cycles, and so they changed the law, added party labels to the ballot, and now Ohio has partisan judicial elections, like 7 other states. So let's talk a little bit about modern judicial elections and what they look like. As I said, 38 states use judicial elections to select or retain their justices. States adopted elections in the 19th and 20th centuries, if you will believe it, as a reform method. Prior to that, largely justices were appointed, and there was an understanding that justices were being appointed in quite literal smoke-filled rooms in which enough political horse trading was happening that the public, in a moment where there was a wave of positions being elected across the country that weren't previously elected, grew uneasy with the political decisions as to who was going to sit on the bench. And the idea was that judicial elections were going to bring some sunlight to the process of determining who sits on courts. Lots of elections, when they converted to being, those systems, when they converted to being elections, they actually started out as partisan elections, but even those were viewed after a bit as too corrupt, as continuing to give party leaders too much of a role in determining who sat on the bench. And so many of those states that moved to partisan elections then later moved to nonpartisan elections. Those elections used to be fairly quiet affairs, but as this chart on the slide shows, that has changed. In 1999, 7 states had a sitting justice who'd run in $1 million race, and this is all adjusted for inflation. By 2016, that number was 20, and that number's probably even a little bit higher now. And so high-cost politicized judicial elections became more widespread over this time period. Before this last cycle, it's not just that high-cost elections are becoming more widespread, but they're also becoming more costly themselves. Before this last cycle, we had never seen a single judicial election with more than $10 million in a cycle. But this last cycle, we saw 5 states that had more than $10 million in their judicial elections. But as I mentioned at the top, this is all really quaint compared to this post-Dobbs era that we are in. The 2023 Wisconsin Supreme Court election that took place this spring saw more money than every state Supreme Court election in the country in 2018 combined. And that was a cycle that I wrote about as being highly politicized. So I apologize. The Pennsylvania Supreme Court election, which takes place on Tuesday, for those that don't know, is likely going to be the second most expensive judicial election ever. And so the 2 state Supreme Court elections, the first 2 state Supreme Court elections to take place fully post-Dobbs are the first and second most expensive state Supreme Court elections ever, which really just highlights how different a world we are in today. And it isn't just about the races getting more expensive. Where the money is coming from is crucially important, especially when you're talking about judicial ethics. Since Citizens United, which really set the landscape for easy political spending by outside groups who are not giving to candidates themselves, but running ads directly themselves and often under names that don't help voters know about who they really are. They've taken on a substantially larger role, accounting for more than 1/3 of all the spending in the money in these races, which is not anywhere close to what they spent before Citizens United. But even that number is not representative, because what you want to look at is the states where these groups focus their energies, where they see an opportunity to flip courts or are responding to decisions they don't like. And in those states, these groups often account for 2/3, 3/4, 85% of all the money in an election. Why does this matter for judicial ethics? So first, much of the spending by these groups is non-transparent. So the actual source of the money coming into these elections cannot be identified or would be very difficult to identify. And we did an analysis where we compared transparency in judicial elections spending to a host of other state elections, and judicial elections were far less transparent. You have very sophisticated political spenders who are getting involved in these races because they know how state courts are going to affect their interests or their bottom lines. This leaves voters in the dark and creates potentially huge conflicts of interest that the public, whether it be voters or litigants themselves, are not aware of. But my second point, it turns out the judges themselves might be aware of these conflicts of interest because there's at least some evidence that judicial candidates are coordinating in ways that they are not supposed to be coordinating with these outside groups, enabling them to circumvent contribution limits and partner with folks who may be coming before the court ultimately. This also matters because these outside groups run disproportionately negative ads, they distort judicial records in these ads, and they are disproportionately likely to attack candidates of color, contributing to racial disparities that we see on state Supreme Courts across the country. There's also a growing body of evidence finding that these reselection pressures, the political pressures that face judges when they're already on the bench and running for re-election, actually shape their decision-making. There is research finding that judges are more likely to rule in favor of their largest donors in election years. They are more likely to rule in favor of political parties that support them in election years, and they are more likely to rule against defendants in criminal cases. Why that last point, you might ask? It is because they are afraid of being tagged as soft on crime in an election year, which is often the theme that comes up in judicial election ads. All this data I'm talking about is about state high courts, but maybe some of the most compelling evidence is actually about the trial courts here, where researchers have found what they call sentencing cycles, where judges are elected to the bench in a trial court. They start issuing sentences of a particular length. As their next election approaches, those sentences get longer and longer and longer. They are reelected to the bench, and then when they are reelected, their sentences actually return to the average length that they were when they were first elected. So judges seem keenly aware of their next elections and are changing their behavior accordingly. So if there's one other takeaway from my presentation, it's that the existing ethics and recusal rules just are not cut out for this era of judicial politics. For their codes of conduct, most states have adopted the ABA's model code of judicial conduct, or at least large portions of it, I should say. You are looking at the latest version of the model code. These codes generally limit the way judicial candidates can interact with political parties, but they don't address how candidates can interact with these outside groups that I'm speaking about that both support them and attack their opponents as soft on crime. Following the Caperton decision out of the US Supreme Court, in which the US Supreme Court said that some spending in judicial elections can be so significant that it actually creates due process concerns, the ABA attempted to adopt changes to its model code. Two committees proposed changes, but ultimately those proposals were withdrawn because the Conference of Chief Justices did not support those changes. And so today, largely, state codes of conduct have not responded to the changing landscape of judicial elections. Recusal rules, the rules for which when judges have to step aside from a case in which they may have conflict, they exist in codes of conduct and in some states and statutes. They are, in almost every state, judges are required to recuse themselves in cases in which, quote, their impartiality might reasonably be questioned. But only a few states have updated their recusal rules post-Caperton to address when campaign contributions create such a conflict. And only 6 states have laws or rules addressing when independent spending by these outside groups that I'm speaking about require a judge to step aside from hearing a case. Many states, lastly, don't have procedural safeguards in place for determining when recusal is appropriate. In many states, it is left up to the judge who is accused of having a conflict to decide whether their judgment can reasonably be questioned, which is no way to determine who's deciding a case. I'll move on from there because I'm running out of time, but I'd love to talk more about that. So one last feature I want to touch on, because I think it's important for folks to be aware of in this conversation, is in this new era of judicial politics, something else we are seeing is the weaponization of judicial discipline. So judicial discipline is not without its own risks. In North Carolina, the story you see on this slide, Supreme Court Justice Anita Earls is facing disciplinary proceedings for making statements about the need for greater diversity on the bench and among lawyers who argue before the court, statements that would seem tame compared to statements that many court systems across the country put out, especially in the summer of 2020, amid racial justice protests across the country. And yet she is being investigated for these statements, ostensibly because her politics do not align with others in the state who are in control of these bodies. In Wisconsin, the legislature threatened to impeach a justice, the latest justice during the court, before she heard a single case, because they were concerned about how she would decide cases related to the legislature. Lawmakers in Montana and North Carolina and Texas are actually introducing and passing laws to change who sits on judicial discipline bodies to give more seats to political operators who can carry out the frustrations of the legislature against judges that they are unhappy with. Strong judicial ethics bodies are crucial, particularly in this moment of heightened state judicial politics. And when these courts are going to be asked to serve as a check on the other branches. But one feature of this new era of judicial politics is that these courts and these judicial discipline bodies themselves may be vulnerable to some of the same manipulation and flaws that we're seeing in other institutions in our democracy today. So I will stop there, and I'm happy to answer questions.
Anyone want to get us started with a question? Otherwise, I'm handing it over to Professor Hardaway.
Yes. Oh, you need to moderate.
Yeah, yeah.
I'm like, I'm the resident first questioner. Okay, great. Oh, that's okay. I got you. Okay. Professor Flam.
So I'm not sure I have a fully articulated question, but I'm curious for those of you who interact with state judges, or really any judges, is there any kind of vibe that might parallel what I don't feel like I hear enough, but I have heard over the last 8 years about the partisan judges who align with, or Republican judges basically saying, yeah, everything's crazy, Trump's leadership was crazy. We all think so, but we're not saying anything. Is there a similar strain among judges on the court that, yeah, this sort of deterioration or trend in the partisanship of our bench is terrible, but I'm not going to say anything? Or is it more open in either direction? You know what I'm asking? Like, do judges feel that we are watching our system fail, and for political reasons they're not speaking out? Or is the tenor among the bench, this is our system, it's politics, we're all in?
I'm happy to let someone else address that.
I guess the one thing I would say to that is when I talk to judges about, but I know well, who are, are friends of mine, who have their frustrations, whatever side of the political line they may be on, who have their frustrations about some political moment, the ones that I might talk to about that, they see that as separate from their work, because they deal with cases that come to them. And so they're not on the Supreme Court. So unless, there are some state Supreme Court justices that I am friends with, so there might be some political moment that is coming to their court. But mostly that's not their job, right? And so their frustration might be in that they can't do anything about it, right? But I'm not sure if that's the question you're getting at, but like I think that's like they have the same frustration that I might have, right? Just as a citizen. But they deal with cases that come to them. And that's where their job is.
Other questions? I see we have, I'm not sure, Kelsey, the Q&A function that's on the Zoom, who's manning that?
Yes, we do have someone monitoring Zoom, so anyone attending virtually, if you have questions, feel free to drop them in, but otherwise.
Can I respond to that last question just for a second?
Please.
Yeah, I would say, I think the professor's point is a good one. I mean, once again, it goes back to what I said. You, as a judge, you have to be careful not to do anything perceived as partisan. And I think if you're speaking out on issues like that, I mean, you can talk in a very general sense about matters, about the importance of an independent judiciary and things along those lines. But if you start talking about specific attacks leveled by specific people, you run the risk of coming across as partisan. And we as judges, we have to be very careful. Once again, my job is to be a judge for all Georgians. And so we do have to stay disengaged from, the rough and tumble of politics as much as possible. I mean, that's just the nature of our job. And so we've got to do what we can to preserve that. We can speak at a very general level about the importance of an independent judiciary and staying away from partisanship and things along those lines. And we have to do things to promote the independence of the judiciary and hopefully the nonpartisan nature of the judiciary. But we can't do that. And I know that's frustrating because a lot of people think we're in a unique position to speak out on those issues. But the problem is, in doing that, we can end up undermining, our role as a judge, and we can be seen then as a partisan actor, which we don't want to do.
I'll just add, I think what we mean by like speaking. Is it speeches? Is it writing concurring opinions? Is it anything? You know, I think something that is maybe notable along these lines is in the Moore versus Harper case before SCOTUS last term, the Conference of Chief Justices filed an amicus brief that while they didn't say that you would be crazy to grant the plaintiffs what they're seeking, you know, I think that they did come together, 50 chief justices with various views and approaches to the law, and say that in not so many words, you know, this would be an erosion of fundamental tenets of our democracy. And you know, I think that that's one way that judges and justices can speak out. Perhaps it's not exactly what you had in mind, but I think it's maybe one notable example.
Do we have so whoever's monitoring the Q&A, is that Q&A, is that a question on the?
I think it glitch. I'm not sure.
Okay, great. I just want to make sure I'm not ignoring a.
Give us a second.
I have a question for Judge Dillard. To come back to some things that you were talking about using social media and your unwillingness to block people. How do you deal with comments that go directly to decisions of your court, whether they're your opinions or opinions written by some of your colleagues?
Other than ignoring them, yeah, I don't. I mean, it's a fair question. I don't comment on my decisions. I think, like most judges, I allow my decisions to you know, basically to speak for themselves. I mean, I don't go beyond that. I don't think I'm not even sure. I can only think of maybe one time where I even linked to one of my opinions in a post. And I think somebody was asking about my views on standing. And I just said, well, I mean, I can point you to one of my opinions, but I typically don't even do that because I just feel like, you know, that's, that gets to me. I try to avoid speaking out on particular issues or particular cases. You know, I mean, if it's a CLE, like I said, I might speak at a very general level, but you just have to be careful as a judge. You have to be careful how specific you're going to be when you're talking about issues. I mean, there's recusal issues that come up. There's, you know, if those issues come before you again, you've just got to be very careful about what you talk about. So typically when I'm talking about the role of a judge or what I do on a daily basis, I'm speaking at a very general level, if that makes sense. So occasionally I'll get comments like, oh, I love this decision, or you don't know what you're talking about. I can't believe you did this. I mean, you're going to get some. I don't get a ton of that. I don't get a ton of comments about my decisions. But the thing that happens the most is I'll get like messages or tweets where people will say from other states of all things, like, I need you to help me, you know, and I'm like, and then I'll point to the judicial canons. I can't practice law. I can't give you advice. You need to hire a lawyer. You know, and occasionally I've gotten, you know, ex parte communications. And when I do, I forward those along to my clerk and the parties are notified. But yeah, I don't know if that answers your question, but I don't comment. When it comes to things like that, I just typically have to ignore it, or just say I can't comment on that.
I actually have a question sort of going off of what Professor N just said. I actually wrote my note last year on state actors using the block button and how it can kind of lead to constitutional violations, specifically with, you know, censorship and relating to the First Amendment. And one of the things that, you know, courts consider are whether accounts are used in a, you know, official or personal capacity. There's a couple factors, you know, what is the bio, what is the profile picture, et cetera. Did you make any sort of concerted effort when you made your account to sort of portray it as personal or official? Like, is that even something you thought about whenever you made your account?
That's a great question. And my answer is I don't know that line is easily drawn. I am a judge 24/7. I like to joke that I lead an unnaturally repressed life because of my position. So I treat all of my accounts as if they are quasi-official accounts. So if you know, for example, when someone follows me on Twitter at the end of the day, I'll look and see all the new followers I have. If anybody is from the state of Georgia, I automatically follow them back, unless it's just some account that is a bot account or just something where the bio is so you know, ridiculously hateful. You know, I mean, something that I just can't countenance, and that's rare. But I don't care what anyone's political leanings are. If they're from Georgia, they are my boss, and I follow them. Absent extraordinary cases, if somebody sends me a friend request on Facebook, I accept it. If somebody, I try for all my accounts to be open, because what's the line from The Incredibles? If everyone's special, no one's special. So I want. I want everyone to feel as if I'm their judge, and anybody that wants to follow me can do that. So I try to be a fairly open book, because once again, I think it's important for judges to be accessible and as transparent as possible. And social media is one way to do that.
So a question for Professor Sarah Cravens. You were talking before a little bit about how maybe in Ohio, bipartisan state elections might not be the ideal form of electing judges. So I was just wondering, building off that, what in your opinion would be kind of like a better system for electing state judges?
Oh my goodness. Okay, so that's a whole other can of worms. So not just for Ohio. I'm just sort of not a big fan of judicial elections, but probably for a lot of the reasons that that Doug was talking about.
I have thoughts as well.
Yeah. Oh my God. Because it's just gone so far out of the. I mean, yes, we had the smoke-filled rooms before, but now, I mean, what's happened with the money is just. It's not. When you ask the average person what they know about not even just about electing judges, but about judges, what they do, what would make a good judge. So I teach backtracking. So I teach a seminar on judicial ethics most years, and we start with some basic questions about what are judges, what do judges do, what would make a good judge, what would be the best qualifications for a judge. And second and third year law students even sort of struggle off of like not looking at anything, not knowing those are the questions that were coming, right? Struggle at first to think, oh, I don't know. And then having to answer the questions, have you ever voted? Do you know if you have ever voted for a judge? Do you know whether you vote for judges in the place where you vote, right? With no preparation, there's a little bit of I don't know. These are law students, right? Highly educated people. And so it's problematic to me that that's the way we do this at this point. Now, do I think there are problems with appointment? Absolutely, I do. Do I think there are even problems with merit selection? Yes. So I'm not saying there's a perfect system, but I would go with the short answer. I would go with merit selection. I would probably tweak it a little bit from what it is, but that's my short answer.
If I can just one quick thing, Professor makes excellent points. The only thing I like to say is I hear a lot with judicial elections, oh, they're so political, as if the federal judicial selection process is not inherently political and flawed. That is one of the most broken systems of selecting judges that I've ever seen. At least I'll take Georgia's, which typically is an appointment by the Judicial Nominating Commission, appointed by the governor, and then nonpartisan elections. At least in Georgia, we are directly accountable to the people we serve. There is some value in that. It may be too Jeffersonian for some people's taste. I get that. I don't think it's perfect by any means. Listen, I would love to be appointed for life. Absolutely. I would love to be appointed for life. I'll take it in a heartbeat. But there is, as the professor rightly points out, there is no perfect system. And merit, if you don't think merit selection is inherently political, it all depends on who's doing the choosing and how those people are selected. So there will always be, you will never be able to find a system where you remove politics from selecting judges, ever. You can make it as fancy as you want. You can put a federal label on it. It is all
political. Now, that doesn't necessarily mean partisan political, but it often is. So that's just the reality of it.
There are some states who do it better than others. So one, I will say the Brennan Center's position, and I'm happy to share a report with everyone, is that in this modern era, judicial elections are just not serving those goals that I spoke about, the transparency and the sunshine and accountability. What you have is, in many states, you have elections in which the public is just not paying attention in the way that the professor was talking about, and so they're not actually sort of operating as elections really, or that you are getting the kind of attention you're getting in Wisconsin, in which you are creating all these potentially very significant ethical challenges. So what we recommend is a well-designed, publicly accountable commission to vet and recommend judges for appointments. It sounds a bit pie in the sky, but there are states that have commissions that are very thoughtfully designed and have avoided some of the political pressures that we've seen in other states. The judge is absolutely right. There are merit selection bodies in many states that are not operating in ways that the public would be happy with. There was just a really large fight in New York about a nominee that came out of the Merit Selection Commission. And the public just really hadn't paid attention to that commission before. And as a result, that commission wasn't really doing its work thoughtfully. But you have a state like New Mexico, where its commission is very uniquely designed and ensures that if there is any partisan majority on the commission is required to continue adding members until there's balance ideologically on the commission. The commission is chaired by the dean of the state's largest law school. The state has partisan elections once those judges reach the bench. So if you're interested in accountability, there's a model you could follow. But it's also a state that largely has seen the bar satisfied with the judges that reach the bench through that commission process. And so I think there are absolutely some states to look at for positive examples. That said, judicial elections are very sticky. States are not moving away from it anytime soon, at least a large number of states are not. And so there are also things that can be done to strengthen election systems. For one, at the state high court level, as I said, the most challenging pressures that we see, the most troubling pressures we see are those reselection pressures, where judges face change their decisions while they're on the bench. And as a result, one thing we recommend is that once judges are elected to a state high court, they should serve one lengthy term and then that's it. They should not be running for election while they are also doing the job of judging. And then there are also within election systems, there are things you can do to strengthen disclosure and ethics and recusal rules to cabin out some of these worst pressures. The one last point I want to make about how judges are viewing these elections is there are a number of grassroots groups across the country who are taking up this problem of lack of information about judicial candidates in LA, in Chicago, I think in Houston, where they're publishing information about judges' records in advance of elections, often with regards to sentencing and bail determinations. And the judges in those jurisdictions are often pushing back on these efforts, saying that this kind of public awareness is inappropriate. They're being evaluated based on things they shouldn't be evaluated on. And I think part of what we are seeing is that in many jurisdictions, judges are not used to the public taking these elections seriously, which I think speaks to the fact that maybe they haven't been operating as real elections anyway.
Mr. Rosenblatt, I know you had a question for the full panel, and I also recognize that it's close to 12 o'clock. Do I have space to allow for one more question?
Yeah.
One more question.
So if I could identify one theme that I think unifies everybody's talk here, it's that transparency is a virtue. But transparency is merely the availability of information. Available information may or may not be used productively. And I'd love to hear, I'd love to hear you speak to each other's presentations as well as your own about how you think the information that you all sort of can get revealed through your plans can actually be used to generate something other than more information.
I'm not sure I heard the very end of your question because I was already thinking about something that made a connection with something you said earlier. So I may not be talking exactly to what you said, but I want to say one thing about a connection and transparency. So Doug, you said something about the increased politicization of the discipline, like the weaponization of discipline, which I sort of felt a resonance with. And in terms of the transparency aspect, I think, there's actually something positive in that. I would have said, when you're talking about like transparency and availability, like that's actually not getting us all the way there because that can be problematized, right? And I think, I'm sitting here arguing, well, let's make discipline like more open. And if you're saying, well, actually, you can weaponize discipline and that can be problematic, I would actually say, no, like open the floodgates, right? That's probably not the right word to use, but if it's out in the open, and I don't mean available, I mean actually put out there. You don't have to come and get it. You don't have to come to the courthouse. You don't have to make a request. It is right out in your face, right? Then if it's politicized, if it's done for a political purpose, then you should be able to see through something that is bogus, right? Because some of those examples, you mentioned one of them, but like some of the other ones that I'm aware of, if you scratch the surface of them, you will find there's no violation there. There's no code provision that has been actually violated, right? So you'll see through the politics of it, but you're not going to see that if it's been done informally. If that judge has been, investigated, but then slapped on the wrist behind closed doors, all we know is the news article. And so that's way more troubling, right? So I think actually the more you put it sort of almost aggressively out there and open with an opinion, the better.
Can I respond a little bit? It's a great question. It gives me a lot to think about. I think transparency has to come along with accountability. So if we only share information, but it's bad information, in my research, I said it backfires. It makes things worse. So think about everything that we learn, in criminal procedure. We know about police using data to tell you this is the high crime area. And Supreme Court said that, well, if you have data to prove that this is high crime area, it justifies more coercion. So that's my concern. My concern is that we are using the data to generate a lot of self-reinforcing institution in the criminal justice system. That's not what I want to see in the 2.0 model. So accountability is one. And I think incentives is another issue that I keep thinking about. So think of the drug court as an example. They don't produce good data. Why? Because the funding agency never asked them to properly document everything that they do. And think about where the drug court's money came from. It came from everywhere. They have different funding resources. And these funding agencies, they have different priorities. So you end up having a lot of drug courts claiming that this is evidence-based, but their documentation process is different. Their incentives is also different. So I think we really have to talk about how do we implement the right incentives in the judicial system. I'll stop here.
I'll just say, I think, at least for me, a lot of these wonderful presentations that we've heard this morning, central to the theme of transparency raises questions that I think about a great deal, which is, when we're thinking about a court doing something, taking some action, or a judge doing something, we oftentimes, react as saying that's too far, or that's not far enough, or they shouldn't do that, couldn't do that, what have you. But I often wonder, especially in the context of state courts, what we're comparing that against, and is there some kind of generalized, generic conception of a judge that we weigh certain actions against whether they're, they shouldn't be elected. They should be elected. Is that because judges should or shouldn't be political? And same thing with courts. When courts do certain things, is that too far or something that a court really shouldn't be doing because there's some kind of vague notion of what a court should or shouldn't do? And I think greater transparency gives us opportunities to kind of investigate those questions and learn a little bit more, but also to spin them and to kind of say like, oh, we have so much data, the court just shouldn't be doing this, or the judge is being nefarious. And so I think we just need to be a little more careful and sensitive about what we do with all that information that comes with greater transparency when we think about what, who these people are and the role that they serve and what these institutions are designed to do.
I'll respond quickly by just not responding and saying that you're right. I think there is a responsibility among so many stakeholders in the system, in our legal system. Like, first that comes to mind are law schools themselves and journalists, to speak frankly about what courts are and what they aren't, and what judges are and what judges are not. And I mean, Judge Dillard was speaking to this a bit in terms of his theory of judges being on social media. But I think we've been doing a disservice to students. And so they are sometimes not fully equipped to grapple with decisions that seem like they are outside the bounds of what the law requires. And I think that all of this information can be used so that students come away with not just a knowledge of how to make use of the legal systems as they currently exist, but to think about what their flaws are and what the limits are on using them as levers for change.
The last point I'll make is information is important, but we don't do nearly enough for civics education in this country. I mean, we can't, we can provide all the information we want if we don't have an educated populace, if we don't have an educated citizenry about government. That it just seems to me, in the last however many years, we're not putting in the money, we're not putting in the efforts. I know there's some exceptions to that. I know Justice O'Connor with her iCivics, initiative. I think that's great, but I don't think we're doing nearly enough. I think we can't let our fellow citizens off the hook. We need to promote civics. We need to have an engaged citizenry who's actually taking these elections seriously. And so I just don't think we're doing nearly enough. So that, to me, if there's another side of the coin for transparency and accessibility and information, it's making sure that we have a public that knows what to do with that information and can use it to make better informed decisions on election day.
Well, thank you all for such a thoughtful panel discussion and questions as well. Thanks, everybody.
Thank you.
Thank you.